the resumption of our inquiry on this day, the 8th of May, 2023. We're welcoming you at S12A NCOP building, S for section, 12A NCOP building. I want to take this opportunity to welcome members here at S12A, as well as members on the virtual platform. I want to take this opportunity to also acknowledge and welcome the Public Protector here with us at the venue. Acknowledge and welcome evidence leaders, Advocate Bawa, who's with us, the members of the media joining in their various platforms, our entire support staff, who's always been with us with an able hand, the members of the public in your various platforms, YouTube 48. I want to welcome all of you, colleagues, and say to you we're back with the inquiry. The last time we spoke, in our last meeting, I had indicated a few things which I want to recap on before we start our proceedings. I would have indicated that when we paused the committee sessions, that we're going to be meeting in the next week or two. I would have indicated that the next week following that would have been a week where members were on leave. And I indicated that members should be on standby, that we could resume at any moment. I further indicated that once we resume, it will be in an environment where there's stampede of programs. I did say that budget votes would have resumed. That's exactly what's happening. Budget votes are resuming this week, so there's a stampede of activities. I said that even with that, the work of this inquiry will continue, and I would have asked members to prioritize, knowing that they've got other business and other committee commitments. It is for that reason that you find yourself here today at S12A. So we have not fallen off the stampede, but we are here in this venue because M46 is going to be very active with the budget votes on any given day between now and when they conclude, whether it's in the morning or afternoon. And given the fire disaster, it seems to be the only venue that is big enough after the Good Hope Chamber. And of course, it is quite now a demanded venue because of the work that we're doing. So just a recap on that. I also would have, in closing that meeting, indicated that we were being kept abreast of the work that was being done by those relevant role players who were working very hard to ensure that we resume our work, and that any other issue that could have been a challenge or a problem was being attended to. Meeting here today and resuming our work now therefore demonstrates and to copy it into a letter from the PPSA, copied as a chair in that letter, which has been shared with you, and that what would have been a problem of funding has now been made available for the completion of this process. One of the things I said when in our last meeting, I indicated that when we will resume for the completion of our work. We will not resume to prolong what we're doing. We'll resume to conclude what we would have started in 2022. We'll remain focused on that task as we regather here today. And so from the chair, I do want to thank those relevant role players who would have ensured that the work of this inquiry gets closer to a conclusion, and those role players would include our Honourable Speaker, as well as the Treasury, in making sure that we are here today. But I also indicated in that meeting, as I closed that meeting, that once there's an indication of the availability of funds, that we would issue a revised program. We were holding back on that revised program subject to those availability of funds. So, honorable members and everybody else, we now have received that revised program based on the outstanding work that must be done, but as well as the availability of those funds. And the revised program that you have received altogether gives us 22 days of work of this inquiry from today until when we have to conclude. And we have been thoroughly explained that we have what seems to be available and that there doesn't seem to be anything more than what has been made available. I did also indicate that when we resume in terms of the timelines and the program, we will resume and conclude the remaining 4 days of leading evidence in chief by Advocate Mpofu, the legal team of the Public Protector. You would be aware that by the time we paused, they would have gone for 6 days in presenting testimony and evidence. You are aware that we would have received 2 parts of an affidavit or statement, part A and B, and we have had those now for close to 2 months with us. So I did indicate that revised program will, when we resume, we will be kickstarting those 4 days to conclude the testimony of the Public Protector, and thereafter go to evidence leaders, members, closing arguments, draft report writing, audit process, and then the tabling of our report to the National Assembly. And so we gather here today, colleagues, having issued this invitation for this meeting. There would have been correspondence that we received from the Public Protector. I'm going to take an opportunity that I give a few minutes to take us through the correspondence that she would have written to the committee, or any other remarks that she wants to make before we resume as planned in the program. So that's really for the purpose of our resumption of our work going forward. Before I go any further, I see the hand of Honorable Milam.
Thank you, Chairperson. Chairperson, I'm informed that the sound levels on the feed are not on the feed, on the Zoom are problematic, that there's an echo and it sounds like it's underwater. I just want to bring that to your attention. Thank you, Chair.
Thank you, Honorable Milam. Maybe we can test that. Honorable members who are on the virtual platform, Honorable Sukas, can you hear us?
Yes, Chair, I can hear you. Good morning, Chair, and good morning to everyone in the room. I can hear you.
Thank you. Honorable Fadminian.
Thanks very much. Morning, Chair. The people on the platform I can hear, like I could hear Honourable Sukas very clearly, but both yourself and the Honourable Milam, there is a nasty echo. It's like a waiver, but I think it's probably coming from the way the room is built more than anything else. Thanks.
Okay, let me go to the next member because Honourable Sukas seems to not have that problem. Honourable Lamisa.
Thank you, Chairperson, colleagues, and ndiyakuva mhlekazi kodwa ke uba iyakuhlupha ambokwa intente phaphandle uhlale khona.
Because Honourable Lamisa, he says he can hear very well. Honourable Dlakude.
Morning, Honorable Chairperson, honorable colleagues. I can hear you loud and clear, Chair. Thank you.
Okay. Honorable Fadminian, you might need to reposition yourself and sort out whatever that you have there. All other members seem to be connecting well with us without any echo. So just check that you don't have many gadgets open there where you are. And then fix what you need to fix. Honorable Olamola.
Yes, Chair. I don't think there's really a contradiction, but the issue is we can hear you, all of us, but there is that kind of echo that is, it sounds like it's at your back or something. So I think I agree with what the member that says it may be an issue of where we are and all that thing. So otherwise,
Okay.
we do hear you.
All right. Well, I'm going to ask, firstly, they can switch off the air condition and see how that works. Yes, there is a small sound of the machines. So I'm sitting next to machines, so maybe that's that. But as long as you can hear me, we'll try and see how we fix it. So that have you switched it off? Okay, so it's not an aircon, it's the machine that must be on. It's no way you're going to switch it off. So let's see how we soldier on within that process. Thank you. Thank you, honorable members, for that. Thank you, Honorable Milam, so that we don't have glitches. Your numbers will indicate if it's getting worse or so. With that, colleagues, I want us to then start, as I've indicated, the public protector, just also to indicate that you remain under oath as the person on the stand. So I want to now get over to you to make your remarks.
Thank you, Chairperson. Good morning. Good morning to the members of the committee. Good morning to the public, to the evidence leaders, everyone who's in this platform. Chairperson, I decided to attend the meeting physically today, because last time I was here, you on the 3rd of April, I appeared virtually when you shouted at me and you muted me. I must indicate that this came as a shock because the evidence leaders were allowed in the so-called committee meeting whilst I was kicked out. This inquiry is about my possible removal from office. So it is strange that I can have any, or it can have any business without me. So what I wanted to tell the committee on that day was firstly that the so-called committee meeting was illegal and that the responsibility for affording me legal representation was not on my, in fact, it was not ordered by me personally, but it was the decision of the Constitutional Court. Chairperson, you, when members raised the process, or some of them, you decided to continue with the inquiry. You stated publicly that I would be given an opportunity to respond to the 6-day presentation of the evidence leaders. That has turned out to be not true, because the proposed schedule you released last week does not cater for that right of reply. Secondly, you have unilaterally decided that all my outstanding evidence must be finished in 4 days, irrespective of the major topics which we will still have to cover: the CX matter, the freedom matter, HR-related matters, of which 15 witnesses were called over a period of approximately 25 days, and I'm expected to respond to that in 4 days. The worst was the recent decree from above that it has been unilaterally decided that my legal representation must be limited to the 4 million, which is the surplus from PPSA. I must indicate, Chairperson, that that process was determined, yes, with everyone trying to locate funds to deal with the process. But it's so unfortunate that I have to come here before the committee so that we can deliberate on this matter, to remind the committee on what process is being followed in appointing a legal representation. Remember the letter which was written by the Deputy Public Protector to me on the 1st of March, copying you, the Chairperson of the Portfolio Committee on Justice, and the Speaker, and further the letter which was written by the CEO of the Public Protector to Sianeho attorneys, informing them about not having the funds to continue beyond the 31st of March. So that is the key issue which we need to discuss here. And I must indicate that at the beginning of this process, I was still in the office when you wrote to me after the judgment of the Concord. You asked whether I will have any legal representation and who is the legal representation. I was still within the office. I had to request the CEO as the person who's responsible for appointing a legal representation. And by then, the Sianeho was busy with all the litigation, and legal services and myself, we then agreed that they will proceed with this inquiry. Then the attorneys are the ones who are briefing the advocate. And that's when they also asked which advocate I would prefer to use, which was then Advocate Mpofu, and a letter was written to you and the committee, and we informed you about the legal representation. Currently, I do not have any legal representation. In any event, on Friday, the committee was served with an agent court application to resolve the impasse of the funding. and the illegal committee meeting. We cannot go forward before the issues are resolved. Why I'm saying that, your letter, Chairperson, and your interviews where you were saying, the Concord judgment, including the Speaker and even the President saying the Concord was not specific who should be funding my legal representation. So that is an opportunity for them to clarify that. And I also want to indicate that the letters which were written to the Speaker was because this is a committee of Parliament and I'm accounting to Parliament, and I had expected the Speaker to consider that very seriously, considering the fact that this is a committee of Parliament, but he also decided to not assist and intervene in the process. And as you would know, that the issue of my unlawful suspension is still pending before the Constitutional Court, especially after the unlawful suspension by the President, which the Western Cape High Court decided on the 9th of September 2022, that I should have returned to work, and DA and the President and the Speaker applied for an agent application. Unfortunately, it's up to 6 months now. I'm still waiting for that particular agent judgment, which I think was going to help in resolving the impasse and the violation of my right to work and human dignity. So I think on that particular issue, I will also be raising a serious complaint, a formal complaint with the JSC, especially on the delay on this matter, but that's another issue which I will deliberate on. But then coming back to the legal representation, how it functions, I hope the evidence leader or your legal services should have advised you, Chairperson, that writing that letter and terminating or then saying there's no fees or there's no funds for the legal team to proceed, basically was terminating the mandate of my legal representation. And that was done by the CEO of the Public Protector, who is the accounting officer and responsible for the finances of the institution in terms of the PFMA. So firstly, the profession, I think possibly even the evidence leaders should have empowered you. They were briefed by the state attorney. Same applies with my legal counsel, they were briefed by Sianeho. And in public administration, the CEO, who's the accounting officer, is responsible for that particular process. So in this particular issue, I wonder why, Chairperson, I was expected to come back and we are proceeding today. The matter now is that you'd ask, what have I done? And I asked, why copying Sianeho when currently they are not my attorneys. The SC currently is not my SC as far as this matter is concerned. What should be happening is that Public Protector South Africa, which I've also then, after receiving the letter, which I didn't receive on the 2nd of May, but then finally I managed to receive it because I was surprised by your letter when you were saying there's money and we are proceeding and as per the letter of the Deputy Public Protector. So I then inquired from the Public Protector's office, especially on the issue of the traveling arrangements, because I understand there's this meeting and I understand there is money which is availed. And then that's when the Deputy Public Protector responded and said, they've written a letter, actually even traveling with my protector, it should come out of that particular 4 million, including accommodation, including everything. And I've seen where I'm even told to handle this money properly. Firstly, let me start by saying I don't handle any finances as the executive authority. I don't appoint any attorneys as the executive authority. The Public Protector South Africa, they did the process initially. They entered into an agreement with Sianeho because Sianeho was part of the panel of attorneys on the list of the Public Protector. And they then agreed on the fee structure. They then signed the agreement with Sianeho. In terms of the PFMA, that's the process they should be following. So we cannot just have a 4 million which is just being availed and there's no accountability. And in some letter, I'm told I must handle this money properly. I don't handle monies. I expect the public protector, because when I communicated with them, I requested even the list of the panel of attorneys, which was shared with me, I think, on Friday midnight or when Saturday around, I think, 12 a.m. And for me to check who's the panel of attorneys which is there, whether Sianeho is still there, because basically that termination of their service by the CEO, it means that they need to sit down with Sianeho. They need to, if it's Sianeho, because again, it should be the attorney of or the legal team of my choice, and Sianeho should be briefing the legal counsel. So basically, the chairperson, I'm sitting here. I don't have the legal team to represent me, and I'm accounting to Parliament. I'm here, and again, you've received the necessary court papers, and I think you were asking why can they proceed with the matter pro bono as they are doing. Unfortunately, this is a parliamentary process. You wanted to hold me to account, and the process has already started. The Crown Court has already decided that you should be availing legal representation, and they've done a lot, actually, which they were not supposed to do, because all these other matters are dealt by them, because I don't have the resources. And that's the only way I could exercise my rights as a citizen of this country, because if my rights are trampled on, I'll have to go back to the same courts. Some of them, they do indeed listen to me. Some of them, they feel it's fine for me to continuously to have my rights being trampled upon. So the lawyers have not indicated that they are willing to proceed pro bono. You would ask whether did I communicate with them. I haven't communicated to Sianeho, the director specifically, but informally engaged with the legal team. And it's not to say we are engaging on them coming back. So I think, Chairperson, the proper way forward in this matter is that the public protector should start that process. I think you would also want, and even the Auditor General would want to know how that 4 million which is availed is going to be utilized, because the attorney must properly be briefed. The attorney must properly then appoint the legal representation, which legal representation indeed to make matters quicker is to indeed brief the current SC or council. But I can't do that myself, because I'm the executive authority. I don't have the right to do that. And surely yourself, I don't know how you operate, but properly you cannot, as a member of parliament, engage and tell what the evidence leaders must be doing. You, through your legal services, communicate to state attorney. State attorney engages your counsel on what needs to be done and on the briefing which needs to happen. So I would then indicate before this committee that that's the proper way of doing that. And lastly, Chairperson, I think is the issue of the current arrangement which is there, because the Deputy Public Protector writing letters to me, and as well instructing me how to handle the matter. I'm the public protector of the country. I should be engaged properly, and hence I'm saying I am not willing to engage myself in an unlawful and illegal process, which will put the institution to further scrutiny on how the money is being utilized. So I think it's very critical that the committee as an oversight and members of parliament should then plead with them also to make sure that they follow the proper process. So attorneys should be properly briefed since they terminated their service. And they wrote a letter to them on the 31st. They actually before the 31st, I think the 30th of March, where they said to them, besides the letter which was written by the Deputy Public Protector, which I responded to, that indeed they don't have money, they cannot continue beyond, but they were asking how much do they need, which is the proper way of asking to complete the process, this final process. And they couldn't respond because it was when there was no agreement with their backroom meeting on the days of my testimony, the dates which are available. So, and then I think that was on the 30th, but on the 31st, they even indicated and stressed that irrespective, we don't have money. So that was what transpired, Chairperson. So I'm here, I don't have legal representation, and I will ask and plead with you that let's postpone this hearing. Let PPSA follow the proper process, appoint the attorneys, agree on the terms and conditions, appoint and brief the legal counsel, and then we can indeed proceed with the hearing. Thank you.
Thank you, Public Protector, for the presentation you've just made. Members, maybe this is what I'm going to want us to do. I'm going to give you an opportunity as members to briefly interact with this. And after that, with any responses to that, I will then come back as a chair and make a ruling on the matter. But I do want to invite you, if you have got any issues you want to raise, having listened to what I indicated is the purpose of us being here today and the response of the Public Protector. I invite you for that opportunity. Just see hands. Honorable Mailam. Any other hand of members who want to either raise clarities or questions or any other comment you want to make in this regard? Nothing on the virtual yet.
Chair, I'm unable to raise my hand. My name is Begibus.
Okay, I note you, Mr. Ngosi, Honorable Ngosi, followed by Tlakude, Maneli. Any other hand? Any other hand?
The corner nam Mkhwebane, then I'll not return that.
All right. Now seeing those hands. Thank you, members. I now proceed. Honorable Mailam.
Thank you, Chairperson. Chairperson, I have two issues that I'd like clarified. The first is, it's my understanding, and I think I got this from Parliamentary Legal Services, that the judgment affording the Public Protector legal representation said exactly that she was entitled to legal representation, but it did not require Parliament or any entity of state to avail, which were the words that the Public Protector used, legal representation to her. And so I'd like that corrected if that is indeed the correct understanding of the matter. The second issue that I have, Chair, that I'd like clarified is, and I'm not an attorney, I'm not an advocate, but it's my understanding that what happened in this particular instance is that the money ran out. And as such, we basically hit a pause button as far as the Public Protector's legal representation was concerned. And so we're now resuming. It's not a case of going back out for a new procurement process for new legal representation or anything like that. It's a case of resuming because the funding has been found to continue. So I'd really like some clarity as to that, as to whether or not my understanding is in fact correct. Thank you, Chairperson.
Thank you, Honorable Mkhwebane. Honorable Nkosi.
Thank you, Chairperson, and good morning to the Public Protector and the members present. Chair, I think I've heard you properly, and for me, I think as a matter of principle, the moment we involve ourselves as a committee in the funding arrangements of the Public Protector's representation, that's when we embroiled ourselves in this difficulty. Now there's an expectation that we should assist resolve matters that are really not within our purview. And that difficulty will continue as long as we think we have got the ability to do so. However, because we have done so and maybe set precedents, perhaps we should assist. I don't agree with that. My understanding, Chair, is the following: that one, the Public Protector lacked funding. That funding has been availed because of the processes that were entered into between that office and yourselves and the Speaker. We now have that funding. We have 4 million. And my understanding is that that is all that is available to assist this process come to conclusion. And I think we should stick to that. There is no additional funding that is available, and we should stick to that 4 million that the budget allowed us. The second thing, Chair, is that where we are, all evidence has been presented to this committee in writing, particularly by the Public Protector. So it is there, it is written, it is available to us and accessible to anyone who wants to go through the evidence. So all that is needed is to lead the final part of that. I think it's about 120 pages that is left. And I think in the period provided, it should be possible to do that, including what we have outlined would be the cross by the evidence leaders and the questions from members and Audi to the Public Protector and thereafter report writing. So I think the period permitted is very, very important. The next issue, Chair, is whether we continue at this stage with the process without the Public Protector being legally represented. I would have a problem, Chair, if we were to continue without legal representation of the Public Protector, because that would not indicate fairness on our side. And therefore, my suggestion in that regard is as follows. One, that we allow the Public Protector to obtain legal representation, taking into consideration the available resources. We know it's 4 million. So the engagement must be within 4 million. Whether the Public Protector Office assists in that process or she does so on her own, we must allow her to get legal representation. That in order to allow that process to take place, we adjourn this sitting, I mean, the session between now and the next Monday to allow that process to take place. And next Monday, we then resume with the committee work as suggested and indicated by yourself for today, that we are going to continue with the latter part or the presentation of evidence by the public protector. And just to conclude, Chair, then that that will allow fairness for the public protector. We cannot really ambush her. And my request is that there must be reciprocity on her side. She has indicated a willingness to remain in the process and participate to the fullest until it is finalized. On the issue of the court papers, Chairperson, firstly is that we should note that the public protector has approached the Concord on this issue. But we do have precedents, Chair, that on this committee, that when that court or any other court is approached, it does not have the effect of stalling this process. The process must continue. The issues will be ventilated wherever they are, in whatever forum, in this case, the Constitutional Court. So saving those papers does not halt at all the inquiry. It will be a tragedy if that is the case. So my suggestion, Chair, to you is that respond to the papers, or whoever has been served, respond to the papers within the time allowed, but that must not interfere with the proceedings of this committee. I think we do have precedents twice or so of court decisions that have indicated that we must proceed and that whatever issue is ventilated should be ventilated, and that in any way the public protector will have the opportunity to approach court if and when the committee decides either in her favor or not in her favor on 4 charges, and that is where we are. And lastly, Chair, let's urge that we conclude this process. We definitely cannot go towards the end of October or towards October with us sitting in this committee. We've sat here for close to about 6 months or 7 months, and it is inordinately lengthened time. Thanks, Chairperson.
Thank you, Honorable Nkosi, for that contribution. Honorable Labude, are you ready? Not ready. I proceed to the next one. Honorable Olamisa.
Thank you, Chairperson, colleagues. I think I must agree with the last speaker who says we have to tread carefully when it comes to non-representation legally for the public protector. What I would suggest to do, can you hear me?
We can hear you, Mkhwebane. Please go ahead.
All right. What I would suggest we do is for the acting public protector, perhaps to negotiate with the previous team representing the public protector to come back if they agree to work on the capped budget as of 4 million, after assessing the amount of work still to be done. If the old team, of course, is not available, the public protector must get new lawyers in conjunction with the acting public protector. You will recall, Mr. Janki, our chairperson, that you did say that the public protector will be given 6 days, if I'm not mistaken, to make her presentation on the evidence leaders in her absence when the evidence leaders were presenting to the committee. Yes, we will, of course, wait for the Concord decision, but it is important that this issue of Concord or the public protector running to the Concord for verification of their order or confirming whether the state should be responsible for, I mean, rather, who should be responsible for paying for these fees, because you seem not to be clear as well. So let's hear from the Concord. So I support, therefore, the postponement of this matter for a short period, for us to be pushed around to say we have to finish this and that, yet we are violating the procedural issues. Then it's risky that this work we have been asked to do might end up being led to litigation by the public protector challenging us. Let us go slow and make sure that we clean all this mess. Thank you.
Thank you, Honorable Olomisa, for your contribution. Honorable Maneli.
Thank you, Honorable Chair. Greetings to honorable members and the public protector. Honorable Chair, I think a number of points have already been covered by the input made by Honorable Nkosi. Save to just emphasize a few points. And I'm trying to link this point with what Honorable Mailam would have raised as a second point of the question he raised. Just to remind the committee that indeed what Honorable Nkosi raises as us getting involved in areas where ordinarily would not get involved in. And that, Chairperson, being done to ensure that the process is protected and saved from collapse. And there's been achievements in that regard. And I'm deliberate in stating this because it's linked to that point raised by Honorable Mayor. We had a break, Chair, because the payments were not coming forth. And there had to be an intervention in that period. It is this committee that wanted assurance whether there was a walkout and whether there's a change in terms of the legal representation. And because we did not have anything from the public protector nor the attorneys themselves that indicate that they've withdrawn completely, they are no longer the attorneys of choice by the public protector. That matter was clarified. We're able to proceed thereafter. We've now taken another break because you've had money that runs out, and that we had to also again play a role we shouldn't be, of trying to again save the process from collapse. And I think we must appreciate, Chair, that we have reconvened today because that intervention has yielded the result. You'd not be talking the 4 million if there was not such an intervention. So with that having been said, Chair, I think there should be an understanding that then as you are taking even the break, it's unless I didn't hear you well when you still had aircon issues. I didn't pick up from you, even from the input made by the public protector, that at a formal level, with the 4 million available, there's been a letter formally that withdraws from the process in terms of engaging the legal team. So it's still going to be an engagement to be done. Whatever would have been an engagement, in the words of the public protector, was an informal engagement that would have happened. Now I'm raising this, Chair, from an understanding, unless that understanding has changed, that in the main, these are lawyers of choice by the public protector, but the PPSA comes in on the basis that the funding comes from them, and therefore there have to be something that regulates a relationship that manages the outflow of the money from the state coffers. But necessarily the instructions are more from the client, and the client in this case is the public protector. So I'm just saying, Chair, for me that's important, so that we our expectation are reasonable in that in the main it's about the choice that the public protector makes, not really about the office itself. Otherwise, the office could have appointed anybody by this time, surely, who would agree to the 4 billion. So I just thought it's important to just stress that point. But there's an important point raised by Honorable Nkosi about the evidence before the committee, because we should also not lose sight of that we have evidence that's before the committee, and most of it being in writing, which can be referred to. So at least when we talk about the timelines, we are also including evidence available before the committee. And this has nothing to do, I think, with being unfair. It's a fair point to raise that the evidence is before us, and the timelines are also informed by that. So it's a combination of the two. That you need to still hear, but without ignoring that is already before the committee, Chair. And I take it that even when we talk figures, whether it's 4 million here or not, 4 billion, these are figures that get agreed to. And surely any deviation, Chair, that seeks to go beyond what has been agreed upon, surely it should raise questions about even other matters that are before the committee as part of what it assesses. The legal fees that skyrocket and so on, right? So we ourselves have the duty to curb the costs, Chair, without compromising the quality of what needs to come out of the inquiry. And therefore we'll be the last to push for an open-ended process in terms of the costs, which we also need to take side of. So I thought, Chair, as I said, covered, but I think these points for me were important to just emphasize and link up with what Honorable Mkhwebane would have raised about. The break would have not meant completely starting a new process. And that's why even in your program, it's a continuation. It's not a restart of an inquiry. It's a continuation of an existing process. So I thought it's important that I read that, and that I support that at this point in time, it will be unfair to proceed without giving the public protector an opportunity to consult and be legally represented. And I take it in that fashion, presenting an opportunity. And I think we'll then have to make an assessment. I think that's the only part, Honorable Nkosi, where I may have a slight difference, is that we have to make an assessment on the basis of a report that comes before us, instead of indicating upfront that we would never be able to move forward unless something else happens, right? So that's what also, Chair, I thought, so that when we review decisions based on evidence before us, it shouldn't be like we have been inconsistent as the committee, but we are also guided by information and evidence that's before us and make a determination on how that affects the program and how then the program needs to unfold. But generally, Chair, I accept that we have to proceed at some point, but we must also be fair. And this is the fairness I think you're doing. That firstly, funding has been secured. We shouldn't take that away. And that there's also an opportunity afforded to the public protector to consult with her legal team now formally, and that we know that we are able to proceed, Chair. Thank you.
Thank you, Honorable Maneli, for your contribution. Now I recognize Honorable Zungula.
Greetings, Chairperson. Greetings to the PP, evidence leaders, and members. Chair, even though it is not in the ambit, does not fall within the ambit of the work of the committee. But Chair, we just need, I want to put it out there that it is, in my view, a travesty of justice that a case or an issue that has been with the Constitutional Court for 6 months has not reached a stage of finality whereby people know what's what, because the outcome of that issue does have a bearing on the work that we are doing. So in my view, it is a travesty of justice that we sit here 6 months later, something that impacts the work of this committee is still in the processes of the Constitutional Court. The second issue, Chair, I would want perhaps when you are summarizing and making a ruling, perhaps you start by saying, where are we now? Because the last time we had met, there was the so-called empowering of the committee by the evidence leaders. And you made a commitment that the PP will be afforded an opportunity to respond or to reply to the whatever that would have been put by the evidence leaders. So if that would reflect in the program to say where exactly will that happen? Because my view would be before we can get to the evidence of the PP, perhaps the first thing that needs to be done would be for the PP to respond as you had committed to that particular empowering by the evidence leaders. The other issue, Chair, is that as we sit here now, the issue of the legal representation of the PP has not been concluded. Hence, the PP is there alone without legal representation. Hence, the PP has filed papers with the Constitutional Court for the very same issue, and also the issue of what was done by the evidence leaders. So in that regard, Chair, I still maintain without the legal representation of the PP, we cannot proceed with the hearing, because the Constitutional Court was very clear with regards to the processes that need to be followed. Now, it is not by the committee's doing that there's an issue with the funding of the legal presentation of the PP, but also it is not by the PP's doing. Hence, the courts have been approached to get rid of these uncertainties, because now we are speaking to each other, making insinuations about what could have been meant and what was not meant. That is why there's a court process to ensure that there is a clear guidelines, or there's finality as to who must bear the cost of funding the legal presentation of the PP. Like all other public officials, you can't, I recall you even spoken in one interview that she should have gone to legal aid. You know, it's stuff like that, Chair, in my view, that warrants that the Constitutional Court hearing the matter and adjudicating on the matter will assist in terms of this issue reaching the finality. So in that regard, I don't see how, Chair, we can proceed. I agree with the latter speakers about the postponement, in the sense that once there is a postponement and the Constitutional Court is able to adjudicate and give a determination on the matter, then as we proceed without having any concerns whether we are doing something that could be legally challenged in the future, or we are doing something that you know, could be subject to even tampering with the process and undermining the work that has been done for the longest time. So it is in that spirit, Chair, I would propose that I agree with the speakers that are saying, let us postpone. Hopefully this matter could be heard urgently and a determination could be made urgently. Then when we proceed with the full comfort that no laws will be broken with the process, with the proceeding. Secondly, the issue that the public protector had, and also some of the members of the committee had with the evidence leaders, also in inverted commas, empowering the committee, will also be rolled on by the Constitutional Court. Then, Chair, everything from our side, you know, we'll have that comfort that we are proceeding in a manner that will not be subject to litigation in future. Thank you.
Thank you, Honorable Zungula, for your contribution. Honorable Mautwe.
Good morning, Chair. Good morning to the PP and the colleagues. Chair, I think we are having an exerted effort to complicate this matter when actually it's very simple. And really, it doesn't warrant us to convene to discuss administrative matters that should be resolved by the acting PP and her administration. Chair, the issue of PP legal representation has not been resolved. It's as simple as that. And hence I'm saying we want to complicate matters that are not actually complex. The matter has not been resolved. Discussing these technicalities now is telling us exactly, it's actually confirming that indeed the matters are not resolved. And they don't need to be entertained here, Chair. If really we want to discuss these budgetary issues, Chair, in this committee, then we may as well just call on the acting PP to come and explain to the committee the issue of funding for these proceedings. The same way the PP is there, trying to give her side of the story, why her legal team is not there. We are hearing from one side. So if really want to entertain the issue of the legal representations or the fees, then it's also maybe advisable to call the acting PP. Maybe she will enlighten us on how this matter has worked, and we will be in a better position to then be informed of what needs to happen. Because I don't think she understands her seemingly rational decisions, how they interfere with the work of this committee. We adjourned a month ago, sometime in April. And when we did that, we told you, Chair, that we can't continue with these sittings without the PP's legal team. We come back here, we still don't have the PP's legal team. Now, what if the PP's legal team that was here before, when the time the acting PP comes with money, they say, well, we've taken other matters, because remember, these people are running their own private law firms. They also need to sustain their law firms and all those who benefit out of their services. So they can't be stuck in a matter that is not clear. When is it gonna end? And when can they open their diaries? Their diaries might be full by the time the acting PP is ready with the funds. And that will cause even more delays, which is something that we do not want. So there are serious implications for the work of this committee, Chair, that if not attended to, we will see this matter even still sitting even next year. What we are doing to PP, Chair, is a serious abuse because she must now use her own time and possible resources to go to the Constitutional Court. As you may be aware, there's a matter that was filed on Friday on matters that were clearly articulated already in the judgment that we can't proceed without her legal representation. Now we want to spice it up and say, no, but the judgment never said it must be paid for by the state. Who is she working for? She's working for the state. So how do you want her to pay the legal fees that we as parliament said she must come to account for, which relates to the work she was doing when she is and was employed by the state? So, Chair, my appeal to you is that let's adjourn the meeting. And I think most of the speakers that came before me have expressed that view, that let's adjourn this meeting. Let's allow the opportunity for the acting PP to consult with the legal team of PP, resolve the matter of the funding. Because if you continue, Chair, you'll be doing what we advised against in the past when you, Chairperson, on your own decided to proceed with evidence leaders without the PP and the evidence leaders agreed to actually continue. We have already undermined this process by that. From a point of fairness and administrative justice, we've already undermined this process. So let's not make matters worse. Let's please adjourn, Chair. I thank you.
Thank you, Honorable Maute, for your contribution. Honorable Sukas.
Thank you, Chair. Good morning again to everyone.
Honorable Labode is back. Okay, go ahead.
Thank you, Chair, and good morning to everyone again. Chair, there's a portion of the meeting that obviously I did not hear. But I just have a question, Chair. I have a question around the legal representation, what that means for this committee. And then I just want to say, Chair, this, and I think it's a matter of record, but I think I want to state it again. Over 26 million rand has been spent on legal fees already. The process that we are in is a process of parliament. It's a process of oversight. That process had its perimeters. And in terms of the obligation that we had as a committee and still have, is that of fairness to the public protector. I think we have extended fairness to the public protector up until now. There is the issue of fairness towards the South African taxpayer. And every single public representative that is part of this committee has that responsibility. It is a responsibility that we as Parliament cannot ignore. We are currently in this week starting with the budget vote. We have a responsibility, Chair, that we need to be aware of as individuals and as public representatives. It is important to say that and to also make it, again, a matter of record. And within that context, Chair, it is totally unacceptable for us to continue traversing matters that has been clarified over and over again. The one is the Constitutional Court process is different to the process of Parliament. It's two different processes. How can we want this process to be stalled until the Constitutional Court provides us with direction? How can we do that? You have three arms of the state. One of it is sitting here in this room doing the work of the state. Then finally, Chair, I think for the third that I need clarity on is the issue around the process itself. There has now been made several comments made around going back for the terms and for the legal team to be briefed and for the conversation to be had with the Public Protector South Africa, the office, together with the legal team and the terms. I need an understanding. We are in an ongoing process. The process has not been aborted. It has not collapsed. It is ongoing. So it is my understanding that those terms that was then decided upon would still continue. And therefore, the one thing that is most important for the committee is, what does legal representation look like? What does it mean for us at this point of the hearing in order for us to go? Because the process has had, we've heard testimony from the public protector. I think it went in for 5 days, I'm not sure. Then we had 6 days. Then we had the evidence leader going through everything that we have heard to explain it to us as lay people in terms of law, in terms of the evidence that we have heard. So there is no reason for us, and I truly, Chair, would have to say, I have a problem when we as public representatives continually stall a process or call for it to be stalled, given the amount of money that has been spent here, and we know how we are struggling with our budget in terms of health, basic education, and how people are being left stranded and without their rights being defended. There is no excuse for that.
Have you landed? You done? Are you done? Yes. Oh.
My apologies. Yes, sir. Thank you.
Thank you, Honorable Sukas. Just wanted to make sure that I don't cut you. Honorable Lagode.
Thank you very much, Honorable Chairperson. My apologies. I had to drive to a place
you are
where...
muted, Honorable Lagode. You are muted.
Honorable Chairperson, can you hear me? Maybe I should switch off my video. Honorable Chair.
Okay, try again.
Honorable Chairperson, can you hear me?
Now we can hear you. You can start properly. We didn't hear you at the beginning.
I wanted to apologize, Honorable Chairperson, that I had to move to an area where I can get a better network coverage because of load shedding. Honorable Chairperson, let me start by saying that I really appreciate that the committee and Parliament were involved in trying to resolve the issue of funding of the PP's legal team. And that yielded the result that we are resuming with the work as we have left off due to this to the lack of funding. And also, Honorable Chairperson, as a committee, we cannot ignore the facts that are raised in the letter from the PPSA with regards to the funds. Let me put it like this, Honorable Chair. They said initially 4.5 million were set aside for the process. Then the legal fees escalated to 30-point-something million. As a committee, we cannot, and as Parliament, we cannot ignore this. I wanted us to note it. Then now, an amount of 4 million has been availed. Hence, we decided to resume with the work today. But I want to concur with my colleagues, especially Honorable Nkosi, who said, indeed, we cannot continue today with the work of the committee because the PP doesn't have legal representation. And also, let me make us also not to forget that we have statements that were deposited to the committee by the PP and a legal team, her statements that are before the committee. And also, she made her legal team led her evidence until to the point where we left off because of the funding issue. Let's not ignore that. So my agreeing to pause today until next week, Monday, is to allow the PP and the PPSA's office to resolve the issue of the legal team. even though we haven't seen as this committee a letter from her legal representation saying that they are no longer representing her, but we are taking a word from her son that she doesn't have legal representation. We are taking that from her word. So I would suggest that we pause here this week and we resume next week. I don't think that that will be a difficult thing for the PP and PPSA to resolve that matter of the legal team, because we need them to lead her evidence, the evidence that we already have. It's not like they are going to start afresh. So that is what I want us to be aware of, and also not to mix issues here. We are not starting afresh. We are continuing from where we left off. Then I'm coming to the issue of the evidence leaders empowering the committee. Honorable Chairperson, I think, I believe it was the best thing to do. We were dealing with evidence that was led before the committee. We were not dealing with something that is new. So they were preparing us, empowering us, so that even where we didn't understand, we could understand better. So they did a great job there. Then, Honorable Chair, with regard to the court papers that the PP applied to the Constitutional Court. So I want us, Honorable Chairperson, not to forget that there is nothing that is stopping the committee from doing its work. That is not an interdict. That is not an interdict, Honorable Chairperson, but it's an application by the PP to the Constitutional Court to raise the issues that she's raising, but it has no bearing on the work of the committee. So we are allowing this break for her to resolve the issue of her legal team, Honorable Chairperson, so that we can proceed as a committee, and also to make sure that this process is fair. So far, we have done that, Honorable Chairperson, where there was a need for her to consult or to do what, we allowed for that space. So thank you very much, Honorable Chairperson.
Thank you, Honorable Dlabele, for your own contribution on this discussion. Thank you, honorable members. That was the last member on the platform to make a contribution. Before I go to any summary or ruling, I am going to take this opportunity to invite the PP for whatever last remarks you want to make, PP, having heard what the members are saying, and then thereafter we will make a summary and the ruling. I would not want to close you outside. Over to you.
Thank you, Chairperson. Honorable members, I'll just clarify where clarity was sought. Honorable Milham's questions, I think, who should pay, hence the matter is taken to Concord. That will be dealt with there to clarify the matter. And indeed, I'm before the committee, I'm accounting to Parliament. This process is the first of its kind. I think that has been repeated several times. There was never a process like this. It's a learning curve for everyone. And whatever we are doing here, it's for future generations, and how the heads of Chapter 9 institutions will be dealt with when there's a process like this. So the Constitutional Court will have to then, because the Parliament seems to be second guessing their judgment, so they have to clarify that matter for everyone. And unfortunately, if you say it was a pause button and not a new process, unfortunately, there are letters which will be shared or which are shared with this committee. Letter from the CEO, the accounting officer of the institution, indicating that they don't have the monies. And if you say to an appointed attorney, there's no money to proceed beyond 31 March, I don't know what does that mean. But then again, hence I said to you, I'm not involved in that. I'm not the accounting officer. And Honorable Nkosi, I don't know when you say the 4 million is enough. Indeed, yes, going back to the institution. Originally, there was an agreement with the legal team and there were negotiated rates, and we wrote the letter to the Deputy Public Protector where I clarified that even Advocate Mpofu's rates and even the other legal team, they were negotiated rates which were even below the normal rates which they were charging at the particular time. So there was that agreement, which was done by the CEO as the accounting officer. I was never involved in that particular process, and with the attorney engaging the legal counsel. So I think whilst at the 4 million, Honorable Maneli, I don't know when you say that has been negotiated or agreed to with who, and how did they come to realize that the 4 million, I mean, including myself, I don't know, Honorable Nkosi and Maneli, whether you have practiced in the past and you know that the evidence which is before the committee, the money is sufficient for the legal team to proceed. I can't comment on that. So I think what you are saying, that indeed adjourn the meeting, which I will have to engage and request the CEO to deal with this matter. And there is a panel of attorneys. They are the ones who should be going back and say, on the panel of attorneys, Public Protector, are you still willing to proceed with Sianeho, which is my attorney of choice? And if Sianeho is willing to proceed, then that's what we will be discussing, and then they will brief the legal counsel. And indeed, they were not on a retainer, that you are not doing any other thing. You are only going to be doing this particular work. And on the issue of the Concord, indeed, it's just purely to assist this process, because these matters are interlinked. You might say it's a different process. You don't want to be involved. Unfortunately, the issue of the funds is impacting on your work and the speed of resolving this matter. When the Deputy Public Protector wrote that letter on 1st of March, copying the committee chair, the speaker, and the Justice Portfolio Committee chair, exactly that created chaos for this particular committee. And unfortunately, you cannot say you are not involved in the process. So it's for the court to advise. Unfortunately, there is history. You would say that yes, there's Concord judgments on the matter, because yes, the two matters are relating to my matter before the courts. They said no, you can proceed. And we know that Parliament, the very same Parliament in the past with the Nkandla matter, you proceeded, you dealt with the matters, and the Concord had to tell you that you shouldn't have handled the way you handled the Nkandla matter. But at any rate, it's for Parliament to continue. And if you say the 4 million is enough, we will proceed, and then the funds will be exhausted again, because I understand, which I don't know how they came to that, the money is including the traveling, the accommodation and everything, and whether that will be sufficient to finalize the matter. I think again is doing one and the same thing and expecting different results. So the issue of Honorable Maneli, that it was a break and the walkout and change and everything, I've explained. Read the letter from the CEO, the accounting officer, and I don't know whether if you read that letter as an accounting officer, possibly if you were an accounting officer in the past and understanding the PFMA, and I think it's high time possibly, you know, as committee members, you engage your counterparts in the committee where the Auditor General sits so that they can also make sure that we comply to what the principles and the PFMA is requiring of us. Definitely, if you can do that, because you cannot come here and say it's a continuation when there's a letter terminating and saying we can't pay you. How do you continue beyond that? And as I said, I'm not the accounting officer. I don't deal with the resources. There is accounting officers who are dealing with the monies. So the issue of there's no formal letter to withdraw, the letter from the CEO was basically terminating the services of Sianego. So the CEO must go back to the attorney and they need to agree on terms. And that's what should be happening. And indeed, I'm glad that you are proposing the postponement, which I appreciate. And indeed, the whole week we will have to do that and deal with the matter. So the issue that I'm saying that I'm the client and not PPSA. I mean, I don't understand why do you have to go to that, Honorable Maneli, because at the end of the day, I don't deal with the resources. Even in the past, there's a CEO, there's legal services. I need an attorney. Yes, this is my attorney of choice per the Constitutional Court judgment. And indeed, I told legal services, this is my attorney of choice. Legal services asked, okay, attorney, who is your counsel PP of choice? Then I indicated, based on the fact that they know this matter from a number of matters they defended, they have a lot of information, with the understanding that at least they will be saving this process a long time. That was the understanding. So if you say, Honorable Maneli, I don't know whether you also practiced and you know that the evidence before this committee justifies the 4 million, I can't comment on that. And remember, my statement has attachments which will still have to be placed before this committee as part of the evidence. And there was no one who agreed to that 4 million. PPSA just indicated that there is this surplus which they can avail. There was never a process in the past where they engaged the attorney, because that's what they did. Sit down with the attorneys and then we agreed on that particular money. So I think it's good for us to go back and do that particular process with PPSA. So Honorable Zungula's issue, yes, I've raised in my response to the chairperson that the issue of the legal aid and the way it was raised, and indeed I didn't expect that from the chairperson, which I clearly stated in my letter that unfortunately even the mandate of the legal aid is totally different to this particular process. And if Minister of Justice, who is overseeing the legal aid, should be accounting to them, is the one who's also assisting the Public Protector South Africa with the additional funding. So, I mean, if there were monies there, surely they would have allowed that the monies would be then moved to the Public Protector. So the issue of Honorable Sucros, it's concerning for me to hear you speak like as if I placed myself in this situation. And for you as a member of parliament, I'm very much concerned about the monies which were spent. I never brought myself here. You are one of the parties who said there's prima facie matter. There's a panel of the 3 members who were paid by the very same parliament. And yourself as committee members, yourself being present, you agreed to the expansion of the scope. If you stick to what the 3 panel members dealt with, I don't think we would have been here. And I indicated that for those 15 witnesses whom you listened, there was no issue. And it's concerning for me that as a member of parliament, and even myself, I'm concerned, you are only dealing with what has been availed to me to protect or exercise my rights. If I was Busisiwe Mkhwebane from Kwaggafontein, sitting where I'm sitting, I'm not the public protector, because this is within the scope of my work, and it's a new thing which is happening in parliament. It's interesting that you don't even want to know how much has been spent for the evidence leaders, because there's money which has been paid to those two. It's one senior counsel and a junior counsel. So that money as well, you should be worried about. So I don't think it's fair for you to just come and think that me insisting on that. And it's a constitutional court judgment which said I should be represented. And again, not every Chapter 9 institution head is legally qualified. What Parliament was insisting on, and the Speaker saying, I can defend myself. But then at the end of the day, I think it should be fair, and it should be a situation where, as yourself, this committee, because if you stick to the panel recommendations, we wouldn't be sitting here. But you decided yourself to revert back to the Honorable Mazon as motion, which then expanded this whole process. So I think it should be fair to everyone that it's not me or the lawyers who expanded the scope, it's yourself. And when we agreed with the 4.45 million originally, Honorable Zagute, with the legal team, and the very same agreement, CEO signed with Sianejo, the 4.5 was based on the fact that it will deal with only the panel recommendation, the prima facie issues. But then Uguti, then you decided to go against that. Hence, we are sitting here. I'm also concerned about the monies which were spent. And I think it should be fair to the public as well, to be transparent how much is spent for the evidence leaders, because we cannot only speak about this 26 million. We should be speaking about everything which has been, because Parliament wanted to run this process. You then had to engage the services of the two council who are not employees of Parliament. So I think it should be a fair process, and again, learning from this process going forward. So the 4.5 was based on the assumption that the process will only follow the panel, 3 panel members. But that people who were not even part, or the panel members recommended that their evidence is not necessary, there's no prima facie case, you decided to invite them for 2 days to sit here and to be listened. So I think it should be very fair, Chairperson, that we go back, we then agree with the Public Protector and the CEO, the accounting officer. I can't. That's why I said in my opening, I don't know how the 4 million was came about, and the attorney should determine with the kind of work remaining and the council, then we can proceed. Definitely, we will have to proceed. So, Honorable Zagute, there's a CEO letter, which I think it would be availed for you to, or for committee members to deal with. So, thank you, Chairperson, for allowing me to just clarify these issues for the committee members, and I'll hear from you.
Thank you, Public Protector. Colleagues, we'll take a 10-minute tea break and come back, summarize, and make the ruling. Thank you.
Recording stopped.
Thank you. Welcome back, colleagues, to the tea break. And I want to just do the summary, make the conclusion and the ruling, as indicated. But before I do that, I see a hand. What would that hand be for Honorable Ngosi?
No, thank you, Chair. I raised my hand before you concluded the meeting. Chair, I just want to, for you in your summary to consider the following. That, Chair, the public protector appears before the committee as a person against whom certain allegations of serious misconduct are made. She cannot take the posture that suggests otherwise. I heard what she said, and I think myself and maybe other members would like to pose questions. Unfortunately, she doesn't have legal representation, and therefore it will be difficult to pose this question. But I'm just requesting that in her responses to what we say, she confines herself to what we have said, and not raise additional issues that may require us to ask questions. The accusations she faces are extremely serious. Secondly, Chair,
Honorable Ngosi, I would want to ask you to pause there so that we don't go that route.
Yeah.
And perhaps allow me to do the summary and the ruling. I would want to open this now for further discussion. I respect and appreciate the points you're raising. Perhaps we'll have time to deal with those issues. If that's in order with you.
Yeah, Chair, no, I accept your ruling. It is a ruling. When opportunity arises, I will raise my second point at the particular point. Thank you very much, Chair.
Thank you, Honorable Ngosi, and thank you for your understanding. Colleagues, I think we've got to make the following points first. Maybe just in terms of context and recapping, because I think there would have been one point of the recapping I didn't do. Firstly, there's what seems to be a very creative narrative about what I would have said at the end of our committee session. And I want to explain that. And the context in which that must be explained is that this is an inquisitorial process as opposed to an accusatorial process. Here, us not being in court, driving a constitutional parliamentary process, I would have indicated quite clearly, and I want to repeat today, that the committee session that we undertook is a session that we would have done at any point in our time, or whether at the beginning or end. And the fact that at that point we took a decision to say 6 days later, evidence placed in front of us covering 2 charges, that we needed to unpack that. So it's a decision that were made, and that decision must not be misconstrued with any other thing. I indicated then that that process actually created and opened up opportunities for the public protector, especially because this is an inquisitorial process. In that if it was an accusatorial process, all of the things that were unpacked were never going to be unpacked. somebody would have been surprised in court about that. We were indicated that firstly, there would have been a benefit of a heads up as part of that unpacking. And that the PP, when she resumes, will be in a different and better space to prepare to answer on some of the issues that were raised. And that's a first opportunity of a heads up about what is going to be coming. Secondly, that she has an opportunity when asked questions, whether by evidence leaders or members, that those issues can be attended to. That's an opportunity that she has arising out of that. Thirdly, there will be another opportunity in the closing arguments that would have had a time to prepare. You would know where and what are the issues that are being raised. It never had to do with any 6 days that the chair would have said there was going to be, and therefore, and that there's going to be a response of the PP. If there's any responses in the form of her when asked those questions, when doing those closing arguments, when preparing for herself to do that. So I think that must be firmly put in its correct understanding. So I don't know where the 6 days come from. Certainly do not have been part of any of the summaries that are made. And perhaps whoever would have, because it's clear that somebody is saying there needs to be a response to that, and therefore if we took 6 days to unpack that, then there needs to be another 6 days to respond to that. It doesn't work like that. And I think that must be explained properly and firmly here today. So that's really the first point that must be made. Secondly, there's an issue of postponement that members, and they seem to be unanimous about, perhaps to firstly clarify the postponement. Because one member would have said, let's postpone until the Concord ventilates this matter and make a decision. The proper, agreement and issue raised here is that members are saying, we can't continue today. Let's postpone today and allow for some time, and I'll come back to this issue. And there seems to be an agreement for us not to continue, therefore, in terms of that. Now, on a number of issues that members have raised here, we are resuming the inquiry, Honorable Mkhwebane, as we're doing today. And as it seems we'll all agree to pause for today and do it from Monday. The next point I think that must be explained as part of the summary is that we have been here before, and I've always emphasized this point: the public protector and anybody else in this room, they are within their rights when they are not happy with a particular decision or a process to take that matter to a correct address and a correct platform that they deem fit for that purpose. Since the start of this process, we have had those off-ramp taking up of the issues, not once, not twice, where in that process there would have been an off-ramp to say, we're going to court for this, there's this issue about recusal and everything else. We have always indicated that if the court is the correct address for someone to take that, including the PP, no one should ever try and stop that or try and want to say it cannot be done. It's within their rights to do that. And similar to this issue of going to the Constitutional Court and making that application, we should not have problems with that. That's what she's doing. But what must be understood, which has been which we demonstrated in other past examples, is that such an application, such an exercising of one's right in relation to this process must never be construed as an interdict. The fact that the PP is applying to a constitutional court cannot stop this process from proceeding. She must proceed, and those who must respond to those papers will have to do that as a respondent and so on. But there is no interdict. There's no legal impediment for us not to proceed. And Honorable Sukas has explained this. This is a parliamentary process, and we're a separate arm of the state. The Constitutional Court is going to have to adjudicate on what we're doing, not on what we're not doing. And so it is going to be a Constitutional Court right to determine those issues, those prayers that would have been placed there. So there's no postponement, therefore, that is done on the basis that there's an application in the Constitutional Court, as muted by members here. And so the point must be firmly, therefore, made in that way, that we've been here before, we've discussed these issues. I think we shouldn't be just repeating them. I think members have been firm about us having to, within a fair process, urgently concluding on the work that we're doing. And there's been expressly put here today that the issue of fairness to hearings has been extensively advanced by this committee. In fact, we're very generous, because at some point you couldn't distinguish between us and the court process. And it's understandable, this is a novel process, but we're not a court, we're a parliamentary process. And so members are also very clear that, in fact, we meet here today with evidence that has been presented in front of this committee. It's now going towards 2 months, us having that evidence, sworn affidavits, statement by the public protector, first with part A's and part B, 124, 54 pages, all of that, we have that evidence. There's no new evidence that is in front of this committee, unless that is still coming. If there's anything, and perhaps I would indicate that if there's anything in addition to what has been placed in front of this committee, not only in this committee, to the panel firstly, and this committee in the form of affidavits, if there's anything additional, we'd welcome that. But as we speak, we've got close to 2 months of written evidence that has been placed to the probing of this committee as it does its work of the inquiry. So that evidence is available in writing, and so the continuation is really about leading on that evidence. It's so far I haven't had anybody saying something contrary. That members in unison are saying we are postponing today's inquiry. We are giving the PP 7 days to get legal representation. We're resuming next week, Monday. And perhaps let me add this properly. We're resuming next week, Monday, with the new or old legal representative, depending on how the work of the PP, what she does. But this is what needs to be clearly understood, colleagues, today before we adjourn, that we're going to resume on Monday with the inquiry, and therefore PP, with either the new or old, the inquiry is going to proceed, and therefore we're not going to Monday for another discussion. that there's now an absence of this legal team or that legal team. This is a parliamentary process. I want us to leave here knowing we expect Monday to resume, and we are resuming as the committee, and that this committee is going to do the work that it is supposed to do to fulfill its mandate. Thank you, honorable members. The meeting is adjourned.